Thank you. I'm CJ Griffin. I want to clarify first that I'm not speaking on behalf of my law firm. I am here in my own capacity. I do work at Pashman Stein. Through Pashman Stein, I represent a lot of, most of the media entities in this room. I've represented before, all on a contingency basis, meaning I don't charge them when they need to fight for government records. I've represented several of the other people in this room that have spoken today and told great stories. I litigated the case that made NJSPA subject to Oprah. The case that exposed the animal abuse at Helmetta Shelter. So many cases over and over again, and a lot of behind the scenes wrangling to get public records because it's next to impossible. I suppose I should have started by saying Happy Sunshine Week, because that's what this week is, and it's a week when New Jersey should be making headlines for doing something that states like Florida or New York have, which is open access to police internal affairs records, which would help Mr. Waters, who spoke a few minutes ago, who couldn't get his own file because technically his file is exempt from Oprah, as is every other file. We've won court battles. You could codify that court battle that we won in Rivera versus Union County Prosecutor's Office. That would make a custodian's job easier. There would be no common law balancing, and it would also enable people like me to be able to sue when those records are denied. But I didn't prepare a speech. I don't like to give speeches. I do have some notes. And so one thing that really stood out to me, someone said, pay attention to the alarms that are being rung here today. When the press is telling you this is dangerous, when the people who use Oprah are telling you this is dangerous, pay attention. I've spoken to before the clerks at their association, at their conventions before. I've given trainings. Custodians call and pick my brain. Agency attorneys respect me. I think I'm widely regarded as an expert. This bill is dangerous. And the comments here today make, I think a lot of us are very angry about the process, that the people in this room weren't involved in it. And the comments here today by some of you make me feel giving you the benefit of the doubt that some of you are just terribly misinformed or intentionally misled by the League and the other agency-side organizations that have been lobbying for these changes for a very long time. And so, Senator Sarlo, you talked about video footage and someone requesting, 2 days or 3 weeks or whatever video footage. Video footage like that is exempt. I know because the very first Oprah case I took, someone wanted a video of the parking lot of the mayor in the township of Bloomfield to show that he was double dipping 2 jobs at once. She wanted to show it. I said, sure, it's my first case ever. It went to the New Jersey Supreme Court and we lost. So you can't get video footage already. Only in limited circumstances, not under Oprah, but the common law. So this is an example of examples that are being given to you that are just not rooted in reality. So another one is that public agencies are sued over clerical errors, and then they have to pay legal fees. No, that's not true, because there's a case called Greco versus Haddon Heights that says that's not true. The security camera footage was Gilleran versus Township of Bloomfield, because I like to give receipts. There's also, a suggestion that that you could sue because it's on the website and they told you to get it there and you didn't give them a copy. No judge is going to fine you in violation for doing that, and they're not going to give you fees. And guess what? Tom Cafferty, Walter Lors, and I are not going to take those cases because we're not going to win. And so that goes to another issue. There seems to be a misunderstanding about what fee shifting is. So what fee shifting is, it's in other statutes like the Law Against Discrimination, the Civil Rights Act. What it means is the average person, but also the media, because you noted that there's not very many media here today. They don't have budgets to chase for a public record, right? So it enables someone like me to get the request and the denial and say, you know what? This is a winnable case. Sure, I'll take it for you. I'm not going to charge you a dime. I'm even going to pay the $30 filing fee. And then I go to court, and if I win, and I almost always do, and frankly this bill really does read like a list of all the cases that they've lost. I mean, it does. It codifies all their losses into now wins. Even worse, some of those cases are pending in appeals and they make it retroactive. So even though they lost in the trial courts, now they can go to the appellate division and win automatically if this bill passes. But putting that aside, no one has money to pay. Most people don't have money for an emergency if their car breaks down. So they don't have the $300 filing fee, and they don't have money to hire an attorney. So attorneys like me vet the case carefully because we want to, we don't want to do our work for nothing. And if we win, we get paid. We get paid a reasonable fee, which means the court does which means we usually settle it for much less than like our commercial rates would be. The incentive on a mandatory fee shift means as soon as I win the case, or as soon as I file the case, if it's a good case, the agency backs down and they pay me right away so that they don't have to like incur more expenses in the trial court. If we win, then they also just automatically pay because there's no question that they're going to have to pay, and so they settle it then too. It's very rare that there's ever a fight over attorney's fees, but this would mean there's a fight every time. So then you're paying the agency attorney more fees and you're paying our side more fees when the court awards them. And finally, I want to go to this notion of commercial requests. My senator, Senator Burgess, is not here, unfortunately, but I looked at, she's from Irvington. I live in Newark, a couple blocks from Irvington, and I looked at the Irvington's Oprah log, and kudos to them for making it online. So in the past 5 years, they have had about 5,200 Oprah requests. And I look at them because I said, people are making this claim with never giving us specifics. And I noted 6 times that the words anecdotally was used during the testimony of the first 3 witnesses. And there's never any statistics, there's never any specifics. And so I looked at that log, and about 800 of them were police records, people wanting to know what the police were doing or getting their own arrest records. But just in the past, since January 1, 2023, it was like another 900 of them or so were coded to being to the zoning officer, the tax assessor, the buildings department. And when you look at what those are, and I know this because I just bought a home last year, and so I bought a home, and my real estate agent said, "Oh, we gotta get an Oprah," and then she explained to me what Oprah was, which I thought was cute. And so every time you buy a home, you, or more likely, your real estate agent or your attorney files an Oprah, because permits and code violations are not online, and I don't think that they're in all these data broker databases either, so you file an Oprah request. And so I did submit a position paper. I don't know if you've received it. Some of you have received it privately. I'm happy to send it along. But I estimate if you address commercial requests rather than this bill that contains so many things that are nothing related to commercial requests, but just the league's laundry list of secrecy that they want, if you instead funded some sort of database software for every public agency so that they could put things like codes, permits, violations in a database that you can search. New York City has this. That would reduce Oprah requests by at least half, if not like 60 to 70% for the average agency. So we have ideas. That's what all of us are saying. Listen to us. We have ideas. We can get this bill. It needs to be voted no, and we need to start fresh. But we do have ideas, and we can address the true problem, and I guarantee that we could cut custodians' work by more than half. And I'm willing to meet with you, and so is everyone in this room. So I'd ask all of you to vote no today. Thank you.
One quick question. So you mentioned common law, and could you just comment, so there are exceptions, and you alluded to them: email, telephone logs, calendars, metadata. Could you just quickly explain now, would these not already be considered disclosable under common law as we know them, and so would we now have a conflict if this language stayed in place?
Well, so the way the common law works is even if a record is exempt, you might be able to get it pursuant to the common law right of access. That's what existed sort of before we had statutory rights to records. And so internal affairs records are a good example of that. The Supreme Court held that even though this body hasn't gotten around to making them public like Florida, there's still such a strong interest in them, and that in certain categories you can get them. The problem with the common law is, it requires agencies to do balancing. There's 7 factors, or 12 if you are looking at certain categories of records, and they have to balance your interest against the agency's interest, and guess what? It's the agency doing the balancing, so they always err on the side of keeping it. Whereas Oprah expressly says you have to err on the side of giving it. And then the real problem with the common law is that there's not any fee shifting. And so someone comes to me and they strongly have an interest in the record. Say it's this, actually, a good example of this is the Bergen record. I sued for them. There were Oprah claims as well that allowed me to take the suit as a contingency because I knew I'd get some portion of the fees for the Oprah claims. There was a dispute that happened in public between the Garfield Board of Education and a member of the public. It was a verbal spat carried over into the parking lot. The reporter requested the security camera footage and then other videos because they even denied the video of the public meeting. The judge carefully reviewed the video, ordered it to be given in a redacted form, and even then, I mean, the custodian wouldn't give it, and then they delayed that lawsuit and appealed, and then delayed that extension after extension until the election was over, and then they suddenly gave it up. So my point being, no one gives access to records under the common law without a fight, and no one can afford the fight. And another important point on this notion, because there's a lot of kind of accusations against lawyers like me, and I think I'm well respected by everyone, including the courts, but an agency attorney gets paid 100% of their bill, even when they lose, and even when they bring frivolous lawsuits or frivolous defenses. And I will tell you, in most of my cases, if I think there might be a dispute over fees, the client will request the attorney bills, and it's almost always that they billed significantly more time on the case than I did. So right now, I just sued for the Tap Into Newark against the Newark Board of Education over a settlement agreement that they had with a developer. Settlement agreements are 100% subject to Oprah, but they fought the lawsuit, and their claim was that they had attorney-client privilege with their adversary that they settled with. The judge, of course, rejected that, and so now we will be settling fees. I billed 62 hours on that case. I had to draft a complaint and 3 briefs go to court. They billed 106 hours, and they drafted 1 brief that was much shorter than any of my briefs and went to court. So if there's abuses, I don't think it's on our side.
Thank you, thank you. And just, I apologize. The law firm was listed on here. That's the only reason why we read
Someone signed me up, so I apologize.
it. Yeah, I just want, in full transparency, we wanted to make sure. Thank you. If the first panel could step away, second panel.